Former SARS Deputy Commissioner Ivan Pillay was the latest witness to testify at suspended Public Protector Advocate Busisiwe Mkhwebane's parliamentary inquiry. He spoke virtually, revealing that litigation challenging Mkhwebane's adverse findings against him had reached 4 million rand, a bill that is likely to be footed by her. What were the outcomes from today's session, and how does this feed into the bigger impeachment case? Legal analyst Modidima Munnya joins me now. Thank you very much for your time, Modidima, and welcome to the program. Let's talk about the money first. Is Advocate Mkhwebane or the Office of the Public Protector liable, and why?
Yes, good evening, Imani and your viewers. Look, the many cases that the public protector was involved in the court, some of them have got court orders that she must pay personally, but in most of the instances, the costs are to be borne by the Office of the Public Protector. So it will be the state finally and the taxpayer who will foot the bill.
Well, that's interesting, especially given, the way some of these reports have been framed, because if you listen to what Ivan had to say, he said some astounding things, including that he believed the report into the revenue collection unit, which Mkhwebane dubbed the rogue unit, formed part of efforts to capture SARS. How much did what he have to say strengthen that position?
Well, I think he has been asked very specific and direct questions. One of the questions was whether he believed that the public protector abused their powers to harass him or target him. And he did not answer to that question, and he said he didn't have an opinion on the matter. It is ultimately for the committee to find probably a motive based on the facts. I think my concern is that it becomes a bit problematic when a witness is asked to give opinions unless that witness is an expert. But I think what he has indicated in the three instances relating to his complaints are two main issues. The first one is that there were procedural issues. For instance, in respect of one investigation, he was not afforded an opportunity to comment on the report until it was made public. He only became aware of it in public, and I think the procedures of the public protector requires that those that are implicated are afforded an opportunity to comment. In the second instance, he spoke more about the findings of the court, which borders on either the legality of the conduct of the public protector or the rationality of her findings and conclusions. The legality issue relates more to the fact that he investigated matters which he was precluded in law because the 2-year prescription rule applies. The rationality part spoke more to the issue of the fact that he ignored evidence or did not consider evidence that was presented to her.
That's interesting, and you talk about the court documents. So I want to refer now to the court judgment that set aside Mkhwebane's report on that matter. It raised the ire, of course, as we saw in those hearings today, of her counsel, Advocate Dali Mpofu, who dismissed them, saying, court rulings are just opinions. What's your view on that statement?
Well, that cannot be correct. Even by the stretch of any imagination. I mean, court judgments, unless set aside, have got a permanent binding effect. I mean, you can imagine what would happen if the Constitutional Court were to make a judgment and somebody were to say, well, they got it factually wrong. So are you saying that the judgment is not binding? So that I don't think is a correct proposition. I think the point that he was trying to make is that in the course of determining the matter, the court may have found, may have erred factually, and as a consequence, then the application of the law may have been erroneous. But that is a function of an appeal process. And the Section 194 committee cannot review and set aside a court judgment. And I think maybe that it's important to distinguish what the court does and what the Section 194 committee does. The court bases its decisions on its adjudication of the facts placed before it. For instance, in one instance, the court said specifically that the public protector did not challenge the version of Van Logrenberg and Pillay. That means that the facts that were presented before court are not in dispute, and the court accepts those facts. So you can't come back and say the court made an error by accepting them unless you say relative to the fact that there was another version which was not considered. So I think the idea of saying court judgments are opinions is not necessarily correct and sustainable in law. Court judgments are binding and continue to have effect unless they are set aside.
Is this route, and I think we've asked the question, a similar question differently, but I want to ask it this way. Is this route that Advocate Dali Mpofu, based on what you're saying now, curious to you? That, you know, the aspects of evidence or testimony that will then be read into the record for this impeachment is left unchallenged by him, and matters outside of the purview of this impeachment committee, such as these court rulings, which, as you say, would have had to have been challenged in higher courts, you know, and that's a separate route outside of these proceedings, that he's in a way endangering his client's case?
Well, look, I wouldn't want to comment on his strategy and his approach, but I think suffice to indicate that the committee is seized with determining whether the public protector was incompetent or misconducted herself or acted in an unethical manner. Now, from an evidence point of view, the committee is going to consider what is relevant. So you can raise a host of other issues. But the questions that and the evidence that the committee is going to have to consider is firstly, whether the evidence points to misconduct, and it will confine itself to that evidence that talks about misconduct. For instance, if there is evidence that the public protector, for argument's sake, has not given the implicated parties an opportunity, she would have to explain. For instance, there was a finding of the court that she investigated matters that were outside of the jurisdiction because of the 2-year rule, and that if she deemed it necessary to do so, there had to be exceptional circumstances. She would have to answer to those things. So some of the issues that may be raised may not actually be relevant to the issues that the committee must determine. Nevertheless, I mean, obviously, I'm not sure why he's pursuing those issues. Maybe it's for the very valid reason why he's doing it.
Well, the one reason he keeps coming back to is that, of course, he doesn't recognize these proceedings as legitimate. But there are very important legs, Modidima, that you are talking about that need to be dealt with in terms of reaching a conclusion around her fitness to hold office, the exclusion of testimony, whether or not this committee bears in mind previous judgments on the side. I mean, I can't imagine that they would be blind and deaf, to those developments on the side which do speak to her judgment, and then the breaching of jurisdiction, which you also just raised right now. All of those factors read together at this point, following Ivan Pillay's testimony, where would you say, the strength lies in terms of, and maybe this is an unfair question and a premature one, but in terms of seeing, just how strong her case is and whether she's likely to survive this?
Well, Iman, I mean, one can say at this stage, there are court judgments. And as I indicated, these court judgments don't fall from a tree. This is the process of protracted litigation. It's a product of people making allegations, others countervailing evidence being provided, and the court adjudicating those facts and making conclusions. So it's not as if the court judgments are irrelevant. In fact, part of the complaints arise from the observations and adverse findings made by the court. What the Section 194 committee is not doing is to review how the court reached those conclusions, but to take those conclusions and adverse findings and say, for the purposes of the determination of the fitness to hold office, are there facts which support that? Because the court did not say the public protector is not fit to hold public office. The court found, as a matter of fact, that she investigated matters that were outside of the jurisdiction. It's a finding, and I don't think it's in dispute that she investigated those matters. What the court qualified was to say, if there are exceptional circumstances, now that the court has found not to exist, the committee may have to want to understand from the public protector, how did you reach this conclusion? Because it's now law that if you investigate a matter that is outside of the 2 years, there has to be exceptional circumstances and you have to justify that. The same applies with considering evidence. There's a law, and the question is, for instance, in the case of what the court has found, that Van Logerenberg and Pillay, under oath, gave evidence which was ignored, and the public protector seemed to have relied on assertions made by other people. The court attached more value on evidence given under oath. The proceedings at the section 194 are under oath. The public protector may have to explain why she ignored, if that is the position, the evidence under oath and took assertions by people. I mean, for instance, there's an allegation she didn't verify certain information. It's a finding of the court. She'll probably have to explain to the committee what, in terms of the procedure and methodology, what she did.
It's so fascinating, this education that you're sharing with us, Modidima, and we appreciate your perspective. It's a long way to go, so we'll see how all this shakes out further down the road. But thank you for your time this evening. Legal analyst Modidima Munnya.